Hey everybody, it's Mike Frieder here with On-Call Compliance Solutions, and I'm back with another compliance tip of the week. Today we're talking about DFARS, NIST SP 800-171, and CMMC. I'm asking the question, has anyone actually been penalized for a false claim before? So hey, if you're a defense contractor who's feeling overwhelmed, tired, and alone, trying to understand all of this DFARS, NIST SP 800-171, and CMMC compliance stuff on top of an already colossal workload, if you feel like you're drowning in the hundreds of pages of confusing legalese and hard to understand techno mumbo jumbo, or if you just need help connecting the dots for the leaders in your company between getting compliant and how it can lead to growth and higher profits, well, I've got great news for you. You found your home here at On-Call Compliance Solutions, where we can help you transform into your company's on-call compliance hero. Now, I'm going to be honest with you, it's a little bit of a longer video. You're going to want to stay to the end. It's got a ton of really great content in it, and I'm going to make some funny jokes along the way, maybe if I can remember to. But anyway, let's jump into it, because this is like one of the biggest questions that we have been getting over the last few months is, hey, Mike, has anybody actually even been penalized for this stuff? Like if I don't get DFARS compliant, I don't comply with NIST SP 800-171, does anybody ever get in trouble? And the answer is yes. So I have to be honest, we don't get it. We get the question a lot lately. We didn't used to get it very much, but it's really become a big trending thing as more and more companies realize there's sort of no way out from going out there and becoming compliant and eventually getting a CMMC certification. So again, this is a pretty dialed in audience, and we see from time to time, we feel we really need to take a moment to address this topic. Now, I promise I'm not going to pick on anyone, but generally speaking, by the time we meet someone who's asking questions about DFARS, NIST, and CMMC, they've already been told by either the government or a prime contractor that wants to send them work that they need to comply with this stuff. Now, that really should be the end of it, right? There should be no other conversation. It's, hey, this is the law, and that's it, we got to do it, right? Or get out of defense contracting, which we don't want you to do because the world needs more great U.S. defense contractors. But we do hear a lot of feedback from one of our favorite client types, they're my favorites, the small business owner. And yes, there are an unbelievable number of small business defense contractors out there. And we're a huge fan of that. We really are. In fact, like any government contracting, there are often what are called small business set-asides mandating that a certain percentage of the contract actually be performed by a small business. It's a very cool way to help these small businesses come up and build up. And even better, it's a great way to prevent defense monopolies, which really wouldn't be a good thing for anyone. So we get the question from time to time, but we really get it a lot from small business CEOs. And again, if you're one of those, I want you to know I'm not picking on you. I just know that question's going through your head. I know it is. I'm inside your head. I'm one of you. And company leaders who say, oh, that will never happen to me. And lately we've been hearing, well, I've never even heard of anyone actually being penalized for this. Can you give me an example of someone who has actually been penalized for real because they didn't comply? So look, normal common sense would say, hey, look, this stuff has now been around for years. There's already a high level of scrutiny on cybersecurity, and I can tell you firsthand that on many direct DOD contracts, they will have a cybersecurity meeting with you prior to award to discuss how you're handling cybersecurity, make sure you're compliant, all that stuff. It's serious business to the DOD. Then there are the hundreds of thousands of subcontractors when getting work from a prime. Direct meetings with DOD over cybersecurity doesn't always happen. In those cases, the prime contractor, or even sometimes the DOD, is relying on a self-attestation that you have made that you are compliant. Okay, that's that box you check that says, yes, I'm DFARS compliant. Yes, I have NIST SP 800-171 compliance in place. If you don't check that box, you don't get the work. No checkbox, no work. Or worse, risk damaging a larger relationship with the party trying to send you the work. And this is one of the things I always tell our clients is, look, if you check the box and you're like, no, I'm not compliant, and then you hear crickets, and then your prime goes away and all your work dries up, it's because you weren't compliant. But they don't sit there and tell you that, right? They're just going to say, well, I guess we're just going to have to move down the list to the next person, just like these guys. Maybe it'll even smell better. Who knows? Anyway, now we don't spend a lot of time on this channel discussing the fines, penalties, and other nasty stuff about what happens. I'm going to be honest with you, I'm a glass half full kind of guy. When you fail to follow the law, every once in a while, a good question comes up that points us back in that direction. What I'll tell you is that if you make a false claim, checking the box and stating that you are compliant when you're not, for sure, without a doubt, you're putting you and the company that you've spent years building, or maybe you haven't spent years building and you're just getting it off the ground, all that effort, you're putting all of that stuff at a massive unnecessary risk. Don't do it. To say the least, we don't condone it. But still, it's a fair question. Has anyone ever actually been penalized for committing a false claim on a government contract and getting in trouble for this stuff? Well, the first thing I'll tell you is that nobody who has been penalized wants their business out there for the world to see, as the reputational damage could be immense. I'm sure it is. Additionally, business penalties aren't often front page news in this area, okay? It's not the most exciting thing, all right? The press don't just jump on stories like this, but we'll do our best to give the information that is available to the public. So here's a few examples that we were able to find. Example number one, all right? Come on back with me in my little time machine, all right? It's July 31st, 2019. An $8.6 million false claim penalty was announced by the Department of Justice, and the complaint was unsealed in the case of the United States versus Cisco Systems. All right, I'm paraphrasing here because I can tell you what it's really called, and the case has got a whole bunch of legal terms that you and I both can't pronounce. All right, so for digestibility, I'm going to shorten some stuff. I'm going to paraphrase a little bit. So, which was a case when a government contractor sold video surveillance software to federal, state, and local government agencies when it knew that the software allowed unauthorized access to government information. Okay, again, I'm paraphrasing, but it's Cisco Systems. They sold stuff that was insecure. So in this case, there was a guy named James Glenn who, as I understand it, worked for Cisco and reportedly repeated that there were security flaws and security vulnerabilities in the video surveillance software they were selling to the government. He repeatedly reported it. Repeatedly reported is kind of an interesting phrase. If you try to say repeatedly reported it like 4 times, I'm pretty sure I'd mess it up. But I read from a teleprompter a lot, so I got it right. Ha! All right, anyway, Cisco refused to acknowledge and never fix these vulnerabilities, putting people in serious danger at places like airports and other sensitive government facilities. After reporting the issue numerous times, this James guy was ultimately fired.
You're fired.
Whoa, he's trying to be a good guy to report stuff. What'd you do that for, Cisco? Not cool. His concern was that he had reported these issues several times, and instead of fixing the issues, they fired him. So what got Cisco really in trouble here is that they were making false claims about how secure the software was and did not disclose its vulnerabilities. It's important to note that this was essentially like a whistleblower case. They fired the dude who was trying to fix the problem, to cover it up probably, and then that guy essentially said, screw this, I'm going to go sue you on behalf of the United States government. And that's an interesting topic, and we're going to cover that in a couple minutes. Ready for case number 2? Yeah, there's more. All right, here we go. Another recent case is one Marcus versus Aerojet Rocketdyne Holdings. Again, I'm going to paraphrase, all right? I'm sure somebody out there with some more exact verbiage, but this is YouTube, and I really don't want to do a whole bunch of legalese up here. All right, so essentially this company made repeated false claims about their certifications to the government regarding DFARS compliance, specifically related to their cybersecurity. The person, Brian Marcus, who related the case was their senior director of cybersecurity, compliance, and controls for this missile defense and rocket engine technology company. The company held contracts with both DOD and NASA. Essentially, Brian brought the case to the United States, alleging that his employer did not comply with applicable DFARS regulations and repeatedly made false claims and misrepresentations to the government about its compliance. After the government refused to intervene, Rocketdyne tried to dismiss the case, asserting that the alleged noncompliance was not material because basically they did the work they were supposed to, they delivered it, it was fine, everything's good, quit bugging me about this silly compliance stuff. Now, just paraphrasing here, if you're following this, again, a whistleblower essentially lawyers up because he is not pleased with his employer's handling of cybersecurity practices and continued refusal to comply. Files a false claim violation on the government's behalf using this legal instrument called qui tam action, I don't know how you pronounce it, but I'm not a lawyer, but I play a good one on TV or YouTube, whereby a private citizen can sue a company on behalf of the U.S. government. Whoa, that's pretty freaky, all right? I know, it's a little crazy, but that's how our legal system works. So here's a tip for those small to mid-sized business owners that think they can just sweep this stuff under the rug. And again, I'm not picking on you, but we're both smart here. And I know what's going through your head. You're people who have to check these boxes. They may not be so cool with falsely claiming you are compliant when you're not. If they really want to, there's a proven roadmap for taking action and suing the employer with the full power of the U.S. government behind them to recover money. Yikes. Okay, back to the story of Rocketdyne. So they try to have the case thrown out. However, the courts say, no way, Jose, or no way Rocketdyne. And here was their explanation, okay? The court also noted that even if the government awards a contract knowing that a contractor has areas in which it is not fully compliant, so even if the government knows you're not compliant, that doesn't mean that the contractor can rely on the government's knowledge and acceptance of partial compliance to then proceed with performance without ever becoming entirely compliant. Ooh. Therefore, if the clause is in the contract, like all other requirements, and again, because of the Christian doctrine, which I won't go into, it's in your contract even if it's not. We've talked about that numerous times on this channel before. If you're doing defense work, it's in your contract, whether it's written there or not. Okay, just like you wouldn't go down the street and steal a car. That's not written in your contract, but you'd be arrested. So, therefore, if the clause is in the contract, like all other requirements, the contractor needs to comply with it. If there are areas where contractors are still working towards compliance, those should be accurately and fully disclosed. Ooh, that's in an actual formal court filing. Okay. Now, my final piece of understanding here goes back to the whole key tam thing. All right. Check this out. Key tam provision at 31 USC, blah, 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 insert law here, allows individuals to file an FCA or False Claims Act complaint on behalf of the government. The complaint must be filed under seal and served on the U.S. Attorney for the district where the case is filed and on the Attorney General of the United States. So, number one, you want to know why you can't find these cases out in public? Well, it's because it has to be filed under seal with the U.S. government. So, unless it gets unsealed, all of these cases are private. So there's a big answer to it right there. So basically, anybody can do it, and they force the government to get involved. So I make a complaint, and for free, I get the U.S. government and its entire budget and backing of its legal all behind me, right? To present this False Claims Act violation. Man, if I'm a private company and I get hit with that, and I wasn't compliant, I'm kind of peeing in my pants. Just gonna put how it is. Yuck. Okay, so what's the moral of the story here? Again, while we don't talk about it often, defense contractors are required by law to comply with DFARS laws, including DFARS 7012. If you want to get technical, it's 252.204-7012. You know the rules. The NIST SP, and if I messed that number up, I probably did, but anyway, you know what I'm talking about. The NIST SP 80171 compliance standard required as a part of it, and a failure to do so can trigger a lot of different penalties. But the most likely penalty is a False Claims Act violation, and that's what they're using. Worse, the big thing to know here is that some of the largest cases have actually come from ticked off insiders. You know, the IT guy in the basement with the red stapler. You get it. Who knew what the right thing was to do, and the company didn't support it. Now, I bet you likely didn't think that's a big way to go and get busted, right? I mean, that's probably not what you're thinking. You're thinking, oh man, you're gonna get busted through an assessment. Hey, dude, this thing can come at you through multiple angles. It's no joke, all right? Now, we honestly haven't even gotten deeply into all of the other government bodies who can land you in False Claims Act hot water. That is also another really challenging phrase, False Claims Act hot water. I dare you to say it 5 times fast. Hey, if you said it 5 times fast, you're watching this video, you play along with me, go to the comments below and tell me I did it. Maybe with a big thumbs up. And if this video gets 10 comments, I'll show you the back of my head. I'll get more into that in a minute. Anyway, just keep in mind that along with internal and external whistleblowers, there's also DCMA, the Defense Contract Management Agency, and their favorite friends at DIBCAC, right? The people who assess. Then there's DCSA, the Defense Counterintelligence Security Agency, and more who have the right to audit you at any time and verify that you're in fact compliant as you say you are on paper. It's a lot of people coming at you, right? It's just easier to get compliant. So hopefully this information is helpful in justifying the immediate need to follow the law and get compliant now. Not like eventually or in a reasonable amount of time. Like, just do it now, all right? You don't want to land yourself in this position. You just want to do the right thing. Look, go do private business, all right? If you're too lazy to get compliant, go back into private sector. Get out of defense contracting, all right? If you're dealing with defense stuff and they're sending you sensitive information about our military, just do the right thing. That's it. It's pretty easy to deal with, right? Not a big deal. So, it's a fair question. Has anyone ever actually been penalized for committing a false claim on government contract and getting in trouble for this stuff? Well, the answer is yes. Hopefully this information is helpful in justifying the immediate need to follow the law and get compliant now. Now, here's the meat and potatoes of what I think is highly relevant. In both of these cases, it's important to note that an inside person had knowledge of the non-compliance, tried to do the right thing, and get the company compliant. The company dismissed the efforts, didn't fund them, who knows, but whatever the reason is, they didn't do the right thing. Then there was a whistleblower. And essentially, what these people can do is go hire a lawyer and sue on behalf of the government, the company who is not complying, and with the full backing and effort of the government, go after the company. Freaking yuck, dude! Or you can just get compliant, which is better for your company and frankly a whole lot cheaper than all the lawyers involved here. Now look, there are a lot of lessons here, but the bottom line is that this absolutely has happened and does continue to happen, oftentimes behind closed doors and oftentimes under the seal that's required of False Claims Act, okay? So if you ask me, here's the deal. On-call is the easy button. We can help you get compliant in the right way, and if you are one of those companies out there who is refusing to get compliant and kicking the can down the road, be aware, legal action has been being taken since all the way back in 2019 on this, and you are not too small or too large to have action taken against you for not complying. And it's scary because it's U.S. law stuff. Hopefully, this makes it all a little more real for you. And if your bosses or owners need a little more convincing, smash the subscribe button and hit the like button right now, then share this video with them. And just for fun, if this video gets 10 likes in my next video, I will reveal the back of my head. So hit that like button now if you want to find out if there's a youthful head of hair back here, or, whoa, I didn't see that coming. That's a huge bald spot. In fact, comment below to let us know what you think and maybe make some bets. And hopefully in our next video, if we got 10 likes, I'll show it to you. All right, and meanwhile, at On Call, we take defense contractors just like you who've had this DFARS, NIST, CMMC, ITAR, and EAR information security compliance stuff dropped in their laps like a seagull on a sunny day. And we teach you how to level up and be a proper on-call compliance hero for your company. Eliminating gaps, gray areas, and getting this solved, all while showing you how to leverage compliance as your secret weapon to land more defense work with higher profit margins. Now that's what becoming an on-call compliance hero can do for you. Looking for more information about getting compliant? Our compliance experts are always on call for you. Visit cmmccompliancesecrets.com or check out the bio below for links to get help right now. There you can find more information about how we can help, self-schedule time at your convenience with one of the compliance experts through any form on our website, and learn more about our completely done-for-you services that can have you on your way to being compliant in just 2 to 3 days. And if you love the content we're putting out here for you, help us out with a big thumbs up on that like button, or even better, smash the subscribe button. It really makes a huge difference. We kind of smile every time we see a new person join us. We're like, yeah, team, let's get it. More subscribers. I don't think we're anywhere close to monetizing this, but it is kind of fun. Until the next compliance tip, my friends, stay safe and secure out there, and hit us in the comments below to let us know what you'd like to know more about when it comes to information security and compliance, and I'll see you on the next one.